Good morning. Didn't draw much of a crowd this morning. Now is the time set for oral argument. And we are in Nayeri, correct?
Yes, Your Honor.
Thank you. Now is the time set for oral argument in cause number 1CA TX18-0009, and I'm going to pronounce it Nayeri versus Mohave County. For everybody's information, these proceedings are being both audio and video recorded, and as of recently, we're now live streaming as well. So barring any unforeseen problems, you can see yourself argue on YouTube or through live streaming in a couple of weeks, or I suppose on somebody's video recorded this afternoon. Counsel, each side will be entitled to 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. An appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid, or try and avoid, taking up all of your time. However, ultimately, saving your time is up to you. We've reviewed the briefs and conferenced the case, so we are well aware of the facts and issues attendant to the argument. You might want to keep that in mind in addressing the court this morning. And for both counsel's sake, when you come to the podium, I would ask that you state your name and who you represent. With that, counsel, are you ready to proceed?
Yes, Your Honor. Al Arpad for the appellants. Your Honors, may it please the court, good morning. I would like to reserve 3 or 4 minutes at the end. I know how the questioning goes, so anything in that ballpark would be fine, but I would like to have some chance at rebuttal after the county has gone forward. The only issue that we are trying to get decided by this court is the interpretation of ARS 42-18105. These are all long statute numbers, so I'll try to get them right throughout the argument. And that is whether there's a, well, that is how the 5-year time limit applies to tax lien sales.
You know, could you, before you begin, we're confused about what happened. Was there a sale of the liens at issue here?
I don't believe that anyone maintained below that there, well, yes, there was a sale in 2017.
And that's what I should have been more clear. Has the sale at issue in the complaint happened?
Yes, that happened in 2017.
And what's the result of that sale?
My understanding is that the liens were struck off to the county, and the county is essentially just holding them because there's a lis pendens in place and they don't think anyone is likely to buy them under those circumstances.
When you say struck off, what does that mean?
It means they, and perhaps counsel would be in a better position to answer this, but it means that they had a sale, nobody bought them, and so they go to the county and ultimately to the state if they're not redeemed.
The liens do.
The liens do.
So your clients continue to own the property, but it continues to be encumbered by the liens.
Yes, and we are coming up this spring, I believe, on a date when the liens would essentially transfer over to the state if we don't get this resolved.
Why is that? Under what statute does that happen?
I would have to look up the statute number, and again, counsel may know it better than I do, but I believe there's a 3-year date when property that's struck off to the state.
Struck off is a term, huh?
Struck off
Okay.
is, am I using
Okay.
the term correctly, counsel?
It is
What-
a term.
We're wondering why the complaint didn't seek to enjoin the sale.
Well, it did, and that was initially denied, and then Judge Whitten dismissed the case based on ARS 42-11004.
Why didn't you special action that decision?
Because again, there wasn't really anything happening that made it that much of an emergency.
And I'm not suggesting that this is dispositive, but it seems to me that if the sale has happened, whether it's the sale happened and it was struck off, I don't know what remedy we can give you here.
It can be undone. These are undone on a somewhat regular basis. I mean, there are statutes that cover that as well. I didn't brief them, not prepared
Yeah.
to name them off to you, but
So was there an injunction hearing? I didn't see that in our record.
it was labeled as an OSC hearing. It happened, it was very brief, and there's a minute entry. It says, we've had the OSC hearing, we deny this, and plaintiffs submitted, at that time, it was not my current clients, it was this Mohave Valley entity. They submitted a new amended complaint focusing more on the declaratory judgment of this 5-year statute of
I
limitations.
see. So the hearing happened actually before the amended complaint?
That's correct. The
Okay, okay.
amended complaint was a direct result.
And so if we were to grant, if we were to reverse the tax court, then is it your belief that something could happen to undo the effect of the sale from your client's
I
perspective?
believe that's true, and maybe the best evidence of it is that the other party in the case settled and they were able to unwind it with no problem.
Unwind the lien?
Yes.
Okay.
What was the basis of the settlement, if you know?
I
What was the premise that they were approaching in settling it?
You really should ask other counsel, because I became conflicted as soon as the two parties I was representing had different opportunities to settle and was not able to participate in that. So I won't spend a lot of time on 18105 because I think it's very straightforward. It says the sale. It says you have to advertise the sale within 5 years, and we think that means the sale where the property's sold. You can't just advertise, well, there's a delinquency. That's not what the statute says. The statute doesn't say, well, you can advertise that we're going to have a sale and then not have a sale and then have another sale some other time. It's pretty straightforward. We think it's important that that question be answered for taxpayers, for purchasers, and even for the county, so that we know, can a county simply advertise a sale and then keep the tax lien in the deep freeze for 20 years and then come back and sell it later? On prudential grounds, I think you have every reason to answer this. We've got, I hope we did a really good job of giving you a lot of background on this. I don't know that you're going to get better briefings so that some other panel in the future would be better positioned to answer this. And it certainly is going to come up on remand. The only reason it would not come up on remand, and the only thing that I think should prevent you from answering that question, is if there truly is no jurisdiction over the case. And I don't think that's true. And that gets us to the second part of the case, which is all of these different procedural requirements that may or may not apply here and that may or may not prevent you from hearing this unless the tax has been paid.
Let's talk about that then. Why weren't your clients required to pay the tax in order to challenge the lien sale?
In the simplest terms, because none of the statutes requiring prepayment apply. The one that's been characterized as a general statute is the 11004 statute. It applies to challenges to the validity or amount of the tax, and we simply don't think that's what this is. I mean, that's been characterized as a broad statute, and a lot of tax practitioners and Judge Whitten seem to think that it has to apply to everything or the system will fall apart, but it doesn't say that. It says it applies to challenges to the validity and the amount of the tax. And there were arguments about the validity and amount of the tax. If you go read the transcript, the trial counsel, clients were unhappy with the way things had been done, didn't feel things had been fairly assessed, but at the end of the day, realized that the issue that they were going to take up on appeal was this 18105 issue, and that it didn't matter whether the taxes were validly assessed, because the time had long passed to challenge them. So we think 11004 just simply doesn't apply by its terms.
Are there any cases you can point to that apply that logic, that say you don't have to prepay taxes?
Strawberry Ridge is the closest, and I don't think it's on point, but we briefed it anyway because it's the closest, and we figured we were going to have to look at that and go down that road. I have not found any cases saying what validity, in Arizona, saying what validity or amount means, or what's outside or what's inside of that. So that's a brand new thing for you all to decide. We think it's clear cut. We think it can't apply to this particular situation for the reasons we've stated, because you'd never get a limitations case to come up to even the tax court if you had paid it on time. It logically can't happen.
Because it wouldn't be a delinquency.
Exactly. It can't be, it can't apply to this type of case, or you've eliminated the time limitation statute from the code.
And I suppose under the other statutes, 18351 and 52, if a sale isn't timely had, then it doesn't matter whether the tax is valid or not, it's going to be abated.
That's exactly correct, Your Honor.
But
That's
simply
exactly
I'm
correct.
sorry. Please finish it.
I was just saying that's exactly right.
But simply abated. It doesn't disappear. The
Well,
indebtedness. Go ahead.
It does appear, I think what the statute says is that the taxes, the word forgiven appears in some place, but that the tax goes away and the lien is abated, the lien's gone. Now, historically, that was not what happened. All those cases we cited you back up until this new statute in 1979, that used to be the case. The time limit would come into place, but the tax lien still existed and was unextinguishable by any means whatsoever, except paying it or having a tax sale. Those were the only things that could extinguish a tax lien. And the legislature changed that in 1979. They said that they were dealing with tax liens from the 30s all over Arizona that were still sitting there. And the first thing they did was take the 5-year limitation off completely and let the counties go try to collect what they could, even though it would have been barred before. Some questions were raised about that, and a few years later they decided that wasn't the best means to do it. How are you going to enforce these taxes and even prove them up anyway from the 1930s? And so they instead adopted the system that says, we're bringing back the 5-year limitation, and we're going to add abatement to it. It goes away if you don't collect it in 5 years. It's a use it or lose it situation. And it's intended to keep the tax rolls clean so that purchasers can understand what they're buying, so that everyone can have clean title to their property. I think it is critical to look at the other prepayment requirements because they operate slightly differently from 11004. 11004 is, although it doesn't use the word jurisdiction, it's a bar the courthouse doors type of a statute. It says you can't come into court if you don't do this. And if you haven't done it historically, it's something that you had to do at the time. It's not something you can do preparatory to coming into court. The other ones operate differently, and this gets us back to Strawberry Ridge. The 16210 statute applies to tax appeals. Again, this isn't an assessment appeal. It isn't that type of case, so that doesn't apply. The 18352, which is the abatement statute, is probably the most similar because that does at least deal with, it does at least talk about limitations cases, but this wasn't brought as an abatement appeal.
What, that's a puzzle to me.
I think trial counsel just viewed it as simpler to ask for declaratory judgment because it would dispose of the case. And my clients now came along in the middle of the case. The original plaintiffs had asked for an abatement and had not received it. And so they went forward and said, can we have a declaratory judgment? And I think it was just they thought it was the simplest thing, that the 18105 question disposes of the case. Then the Nayeris signed up because they had not submitted an abatement request, but they were situated exactly the same in all material respects. And so sending them back to do that would be futile in terms of prudential considerations on review.
Would the procedures and the rights outlined in 18351 and 18352 naturally follow from the consequence of a time-barred tax lien sale?
I believe so, if I understand your question.
I'm sorry. A time-barred tax lien sale is one of the grounds that on which a party may seek abatement of the tax and to remove the lien, right?
Right.
So would that be what your clients would do if you're successful on appeal?
If we have to go through that, yes. I mean, I think the tax court frankly could say this is time barred, we're done here.
But then the lien would still be there, right?
That's true. They would have to go back and ask the county to remove the lien based on the declaration of the law. It should be pretty perfunctory, but that is what would have to happen. And I don't think anybody at this point is contesting that we can do that because there is no time limitation in 18352. The problem would be that if you think that's the route we have to go, then you would have to at least reverse the judgment so that we're not barred by res judicata by having our entire case dismissed under 11004 so that we can go back and do that. But at any rate, we don't think that applies. 18352 applies because it isn't an abatement appeal. It's just a straight declaratory judgment action. We think that's the statute that applies. We don't think there's any statute that bars that from going forward without prepaying a tax. If you decide, if you look at this, and I think this is how Judge Whitten and the county have looked at it, that, well, there has to be a prepayment requirement somewhere, so we're going to fit this in the box that seems the most similar, then 18352 is the most similar, and you probably have to look at that. And that takes you to the Strawberry Ridge decision. Strawberry Ridge said that the language in 18352, I don't want to conceal that from you, they said it is a prepayment requirement. But that wasn't the question presented. And I went back and I checked the briefs on this to see whether anyone was presenting that question. And the plaintiffs came in and said, no, we think it's a prepayment requirement, therefore we paid it. That's not the question in front of you. The only question is whether we had to pay it timely. And so that's the question that Strawberry Ridge decides. I don't think that's a prepayment requirement. It doesn't say it's a prepayment requirement. It says if you've paid, you may get a refund. In no other context would that be interpreted as a prepayment requirement other than sort of the knee-jerk idea that in tax cases you got to prepay everything. I don't think that's what it's intended for, and I think public policy, and we've made constitutional arguments to you. Those are not intended to be our primary arguments. I hope we don't go there, but I think it shows you the public policy of why the legislature would say in this type of a case, you don't have a prepayment requirement. Why would you have a prepayment requirement on a statute of limitations defense? The whole point of a statute of limitations is to say that you shouldn't be burdened with this stale claim. But you've got to prepay all the other side's damages plus penalties and interest before you can even say this thing is time barred. If I was in the legislature, I wouldn't put a prepayment requirement on that. I don't think they did.
Couldn't you make the same arguments, though, for taxes that are valued, I mean, or valuation issues or
all of those?
You know, if the legislature felt that way about statute of limitations defenses, they could certainly feel that way about any other obligation to pay taxes.
They could.
You wouldn't want someone to pay more than they have to.
They could, but they didn't. All of those other ones are quite clear. They say you may not go into court as a plaintiff or a defendant and argue validity or amount unless you've paid it. Very specific, says you can't do it. And the other ones are the same. They're either jurisdiction stripping, or in the case of 16210, I think it doesn't say there's no jurisdiction. It says you're going to dismiss the case if they haven't prepaid, which kind of comes to the same thing, but legally, I guess, is a little bit different. But they're very clear. They say if this happens, then you've got to prepay. 18352 doesn't. I'll reserve the rest of my time if you don't have any other questions.
Your Honors, good morning. Thank you.
Good morning.
Please allow me to first state my name. I'm Lenore Knutson. I am a Civil Deputy County Attorney from Mohave County. I represent the Mohave County Treasurer, Cindy Landecox. If you would permit me to allow you to introduce you to Mohave County. We are geographically very large with 13,461 square miles. It's the 5th largest county in the contiguous United States. 2010 census data indicates that population density is approximately 15 inhabitants per square mile. Mohave County is comprised of approximately 260,000 real property parcels. Of those 260,000 real property parcels, Mohave County is strapped with delinquent taxes on approximately 20%. We deal with a lot of delinquent taxes every year, and our tax lien sale is quite large. Most importantly, property taxes comprise approximately half of the general revenues to Mohave County. Without property tax revenue, Mohave County like most counties, comes to a literal standstill.
What's the consequence of the sale that happened here? What does it mean to strike it to the county?
Thank you for that question. It is an arcane term that simply means that no investor, private investor, purchased that lien on the open market during the February tax lien sale. As a result of that, it's struck to the county. It returns to sale each year to see if there's a private investor that may want to pick it up, or it remains available during what's called the over-the-counter sale period as well. So at any point, a private investor could step in, but when it's struck to the county, it's essentially a holding place.
So it hasn't been sold, it's just reverted to the county.
It's struck to the county. It is still owned by Mr. Nayeri.
The land is owned by
Yes,
him, but the lien,
is owned by no one because Mohave County doesn't own liens.
So when I said it hasn't sold, the lien was not sold, it's just held in abeyance, so to speak.
I cannot tell you today the exact status of whether that lien has sold or not. I essentially don't know. It doesn't necessarily change the legal argument. And even if it had been sold, a couple things I want to clear up. There were some misstatements made. If it is struck to the county, it is not 3 years before Mohave County could essentially seek a deed from the state of Arizona and then sell that deed in what's called a deed sale. Lien sale, deed sale.
so there's a statute that allows for that process.
Yes.
Do you happen to remember what that statute is?
I want to say 18303, 42-18303.
18303, okay.
And so what happens is that once there's a county-held lien for a period of 5 years or more, the state then, the county applies for the deed, the state transfers the deed to the county. All counties in Arizona do this, all 15. And then the Board of Supervisors takes the deed. They conduct a deed sale. There are very specific parameters for advertising and conducting the sale for the deed sale. The difference is in the February lien sale, the investor comes away with a portfolio. In the deed sale, the investor comes away with property.
Yeah.
That takes 5 years or more to come away with property. The lien sale occurs every February by statute. So, Mohave County, like most counties, grinds to a standstill without their tax revenue. It's one of the reasons that the statutes have been enacted to balance the interest of the private taxpayer against the orderly conduct of government, supported by those tax dollars.
So what's the argument for why the sale was not untimely?
May I get to that? I'm going to answer it.
Okay?
Thank you. I'd like for just a moment to talk about the appellant, Majid Nayeri, and his wife, Bida Abadan. Perspective is incredibly important here. Dr. Nayeri, along with his wife, maintain ownership of 60 parcels of land in Mohave County. Dr. Nayeri purchased Colorado River frontage via quitclaim deed in June of 2010. That date is important. He purchased it in June of 2010. Dr. Nayeri took title to this Colorado River frontage property with full knowledge of the back taxes and offered an assurance to the then Mohave County Treasurer that the taxes would be paid as part of the sale. That never happened. Dr. Nayeri has enjoyed the use of his Colorado River frontage.
Who did he buy it from?
He bought it from a title company.
So what was the context in which he assured the county that he paid the taxes?
A series of emails back and forth between the then treasurer and Mohave County, and Dr. Nayeri, inquiring, what is the amount? Yes, I'll have them paid. Those are in the record, those emails.
Is there any contention by the county that the county did anything in reliance on those assurances?
Yes, the county did rely on those assurances.
Is there anything in the record that tells us that?
Return emails saying, yes, pay it. If you pay it by this date, it will all of the liens will be gone. It will essentially be current.
But can a county block a sale of property until such time as is there a statute or is there something that says that that if he had said, no, I'm not going to pay the taxes, I'm going to finish this sale and we're going to go from there, what would the county have done?
The county would have done exactly what has transpired, and that is they would continue to send out tax bills for those delinquent taxes. The interest would continue to accrue on those delinquent taxes.
So they did everything that they would have done
Yes.
otherwise. So there was no detrimental reliance. There's nothing they did in reliance on his email that said, I'll pay the taxes.
Well, one of the things that happened is that and again, this is complicated because of the period of litigation that transpired between 1993 and 2009. Federal court litigation that may have affected the property rights. It didn't. And during that uncertain period of time, Mohave County gave all disputed triangle property owners the benefit of the doubt, the shadow that was cast by the federal court litigation. And as Judge Whitten said, and also the Attorney General, then Thomas Horn, when he looked at the constitutionality of House Bill 2178, Mohave County never gave up the right to collect those taxes. They held the taxes in abeyance during this uncertain period of the ARIA litigation. As a result of that, all taxpayers, including Dr. Nayeri, were given the opportunity to pay just the base tax. We'll forget all that penalty and interest stuff because of this cloud of the federal litigation. So they did indeed rely on that.
Is holding taxes in abeyance a term of art? Or as a practical matter, what does that mean? Impose the taxes but then sit back and do nothing when they're not paid?
Well, what it meant is that Mohave County would forego their right to collect interest because county-held liens by statute collect 16% interest per annum. They would forego their right to collect interest and penalties and honor the fact that these landholders were, through no fault of Mohave County, essentially tied up in this litigation, and so they did not push any efforts to collect those taxes, and at the conclusion of the litigation, put the property owners in the same position they would have been in, and that is just pay the tax.
Well, I see in the record some correspondence going back and forth where the county said, if you pay before X date, we won't charge you interest. And that was after the conclusion of the ARIA case.
Yes.
Did the county come to any agreement with the property owners before the conclusion of the ARIA case on terms like that?
There were correspondence with, let me back up. Some property owners continued to pay their taxes without fail in the disputed triangle. So there was never a question of every property owner being delinquent or holding their taxes in abeyance. Some property owners, and a minority, felt as though it was patently unfair to collect taxes when the federal government had clouded essentially their property, that they felt their marketability was reduced, they felt as though their enjoyment was reduced. Again, that was addressed in an earlier tax court proceeding, and the tax court was very clear in saying that despite the fact that these owners felt as though their enjoyment may have been interfered with, the county had a duty to impose tax. So in fairness, starting in June of 2010, when the litigation ended, finally, all appeals, all of the back and forth ended in 2009, almost immediately the county said, okay, remaining taxpayers, just pay the base tax. And that offer continued up through November of 2016. We had 3 holdouts in November of 2016. One of them is the subject of this lawsuit. So all other disputed triangle property owners had paid their taxes. And we now are down to this one case, keeping in mind that all other property owners paid their taxes.
What difference does that make?
Because the same arguments that Mr. Nayeri or Dr. Nayeri now uses.
So we have one plaintiff or taxpayer who's asserting his rights and going to continue to fight. Why does it matter that other people settle?
Well, it's not the settlement, it's that other people honored their tax obligation all along.
But it served these people's best interest to do exactly what they did, right?
they were
And they weighed
put
the
in the
litigation
same,
risks and,
they were put in the same position as to whether they had paid their tax month by month, half year by half year, year by year.
I'd like to actually see if we could get you to focus a little bit on the issue here, which is, I think everybody agrees that you have to pay, prepay your taxes if you're challenging the validity and amount. What is your support for saying that you have to prepay your taxes to seek, to stop a tax lien sale on statute of limitations grounds?
Well, first of all, I would go back to 42-11004. The language is very important, and in relevant part, it says, a person on whom a tax has been imposed or levied under any law, relating to taxation may not test the validity or amount of tax, either as a plaintiff or a defendant, if the taxes levied and assessed in previous years, against the person's property have not been paid.
That addresses validity or amount of the tax, right?
And
As opposed to, there's a statute that says that you have 5 years to make your move.
the statute says you have 5 years in which you must advertise. It is not collection in 5 years, it's advertisement in 5 years. And Mohave County has maintained and continues to maintain all along that we have done that. That issue has never been litigated.
Assuming that we disagree for now, just for this purposes, that, or at least that there's an issue on whether or not the prior advertisements count. What is the support for the idea that you have to prepay in order to challenge the notion that you haven't met the 5-year limit?
It is our position that 11004 cannot be divorced from this proceeding. The record is replete, and the record is the record. It is replete with examples all the way up through the summary judgment and the oral argument on the summary judgment that they were contesting validity and amount.
But the claim is based on the statute, the time bar statute, and which doesn't hinge at all on whether the tax was valid or whether the assessment was valid. It simply says it's too late to sell the lien. And that doesn't take into account the assessment or the validity of the tax. It's talking about the lien, right?
And again, Mohave County has advertised those parcels. There has never been a record made on that issue as to whether Mohave County advertised those parcels within 5 years, without a 5-year break.
But there's no contention, is there, that this sale was advertised within 5 years of a delinquency, is there?
And that's not what the law requires. Pursuant to 42-18104, and the delinquent taxes for which a real property tax lien may be sold pursuant to this article are not limited to unpaid taxes for any particular year. Goes on to say the county treasurer shall advertise and sell the tax lien for the aggregate amount
Right.
of all taxes, unpaid taxes that are delinquent on the property, together with penalties, interest charges, respectively due for the current or preceding years. The failure to include the unpaid taxes of any year does not invalidate a sale for unpaid taxes that are delinquent for any other years.
Do you understand how odd the consequence is of your argument, which is that the county can post an advertisement in 2009 or 2005 or 1998 and then not sell it, and then sell it in 2017 based on the prior advertisement? Who would show up for that?
Your Honor, it's not a break of 10 or 15 years. It is continually advertised.
But
And
not sold.
But that's because there's no buyer.
So you're
There's
not
two
telling us,
things.
excuse me, you're not telling us, are you, that there was an auction for these liens at any point in time before 2017, are you?
I am telling you that during the period of the ARIA litigation from 1993 to 2009, there was a conscious decision to not sell the property liens out from under these parcel owners because of the dispute in the federal
Okay,
court.
so there was no sale?
During that period
There was
of
no
time-
attempt to sell?
During that period of time, there was no attempt to sell.
Okay,
They continued to be advertised for sale. And there are some years post-2009 that they were included in the listing of properties for sale.
what does that mean?
And so there were some years that they did indeed go to sale.
Which years are those, and where do we find that in the record?
I believe there's a table in the record that speaks to the years that and I believe it was part of, and referenced at the oral argument for the summary judgment motion, that referenced the years that it was advertised and sold.
So you're saying that there was a sale held of liens that were, and that sale was advertised within 5 years of the delinquency?
Yes.
And that's somewhere in the record? Did you submit it on summary judgment?
I submitted a table in my summary judgment motion, but again, this matter has never been fully litigated.
Well, but you see, it's relevant to the issue on appeal, which is whether a sale is time barred. So it is very relevant, I think.
In this logic, we cannot eviscerate the importance of 42-18104, which is that advertisement includes all previous years. That advertisement then stands for the premise that this property is sold for this year and previous years.
So what you're saying is that if there's 35 years of unpaid tax liens and you advertise it in the 36th year, the 5-year limitation is wiped away as to the prior 34 years?
No, I'm saying that may have been advertised throughout that 35-year period, and either there was no investor, there's no buyer, there is a multitude of reasons. For instance, bankruptcy, we're subject to the stay as well, that a property has to be pulled back out of the sale.
Okay.
But the statute doesn't require a sale in 5 years, it requires advertisement. That language is critical.
What's your, turning to the other issue, I just want to give you a chance to answer the question. What's your best case for the proposition that the 111.004 applies here to a challenge brought based on the expiration of time?
It is a very narrow read of the record to say that this case is premised only on expiration of time. Every single pleading submitted by plaintiffs up to the point of this appeal talked about validity and amount. It was woven into every argument. It was woven into every pleading. It is not divorced. So if you have a case that brings a challenge to the amount of time and the validity and the amount, which is what we have here, then 11004 controls and says you must pay those taxes. And there is a remedy in 352. If we don't prevail, then those taxes that have been paid under protest would be refunded. There's a statute for that.
Isn't the complaint, though, doesn't it limited to declaratory relief on the validity of the sale based upon the 5-year? I don't see a challenge in here to the amount or the validity of the underlying tax.
I'm sorry, which complaint are you?
Their verified amended complaint, I believe it's record 16 that they filed in this action. So
when they joined Mr. Nayeri, the attention focused on the declaratory relief, but interwoven throughout the documents, including their response to the summary judgment motion, including the oral argument at the summary judgment motion, was replete with challenges to validity and amount. So,
okay, I think you've answered my question.
Thank you, counsel.
thank you.
So I think that did get us down to the key question here. The question is, what do you have to advertise? Do you have to advertise the sale, which is what the statute says, or do you just have to advertise the fact of delinquency and we're kind of hanging on to these, which is not what the statute says.
And we're kind of hanging on to what?
Can you just advertise these are delinquent liens and we're hanging on to them and that's good enough?
Are you familiar with the record item that council spoke of to support the proposition that a sale was had, or these things were offered for sale?
No, I will concede that the record is not crystal clear on that, and if they've got some kind of a case to make on that, it should be remanded so they can make it, unless they have waived it, because we also cross-moved for summary judgment, and they gave a bunch of inadmissible paper that you can't even follow that might mean something. I will tell you what
I'm sorry, go ahead.
What I found really illuminating was I, just a couple nights ago, reread the affidavit of Julia Dollarhide, and it gave me some insight into the county's thinking that I didn't have before. One of the things that I think helps understand what's been going on here is that she seems to think that this 5-year statute works the same way as renewal of a judgment would work.
Yeah.
And so she thinks every 5 years, as long as you do something every 5 years, you've renewed it. And that's just not, I don't think, how it works.
Describe for us, with that in mind, with what you just said in mind, what does work.
What does work?
Draw the distinction between what they're doing and what they needed to do.
What they needed to do, and this is because of the statutes that say when you advertise, you have to then hold the sale between 2 weeks and 3 weeks of the advertisement. So you can't even if you were smart enough to figure out that the year you were going to sell it was 2017, you can't advertise in 2005 that you're going to sell it in 2017. You can't.
Help me just a little bit, and I think I know the answer to this, but I want to hear what you have to say. What exactly did the tax court decide on the issue of the timeless? Did the tax court make a decision that these things were valid or were not valid?
No, the tax court decided two things. The tax court decided that 11004 meant the case was out of court, and just for good measure, he decided that that special law was a special law and therefore not enforceable. There was, in fact, a statute passed that said the legislature didn't think these taxes should be due.
So,
And that's not challenged on
We have not brought that on appeal because my clients can't afford to litigate special law in Arizona, given that there's no law on it.
yeah. So then the follow-up question to that is, let's assume that we buy your argument on the 18005 or whatever it is. What do we do with the case?
You tell us what that means, and then we go back to the tax court and we say, okay, are there any, if there's some kind of estoppel argument about how we waived the statute of limitations, we're probably going to argue you should have made that at summary judgment because we did cross-move, but the parties need to sort that out. What we need to know is, what does that statute mean? That's critical. And we also need to know whether 18352 applies, so that we got to go back and cure the non-payment. I don't think it does, but if it does, we need to know that.
although that issue's not raised.
Yeah.
That issue was not raised in the tax court. That issue,
Yeah.
we brought it up because we
Yeah.
figured Strawberry Ridge was going to make it, you were going to wonder what's going on, how does Strawberry Ridge relate?
But that's not technically before us because it wasn't litigated below.
No, I think that's true. But if there's a prepayment requirement, we would appreciate knowing about it.
Thank you, counsel.
Thank you, counsel.
Thank you, Your
We
Honor.
appreciate your argument today. This is clearly not a kind of matter they're going to be discussing out in the park this afternoon. It's a little bit unique in what they're doing. We appreciate what you've done. We appreciate your patience with us. We're going to take it under advisement this time, and we're going to
If there is anything you need supplemental briefing on, I'd be happy to do it.
thank you.